Thank you very much, Rebecca, for your kind words. Ladies and gentlemen, welcome to the world of GDPR compliance tools. Tools sounds like blue color. It maybe awakens some memories of the old economy, and in a way I think it's fitting. If you think, for example, of the car manufacturing, the engineers can design all kinds of fancy cars with flashy gizmos and interesting stuff, but if you don't have the tools at some point to produce the bodywork, to produce the engine, to produce the drivetrain, those cars will never be seen on the road. And transferred to our domain, we have at this moment a sort of kind of a design in form of the GDPR. But do we have the means at our disposal to put this into production, so to speak? And as Rebecca already mentioned, as in manufacturing, you need a variety of tools, and also in our domain, we have to keep certain aspects or several aspects in mind. For example, the question, software can cure anything. Do we have software at our disposal that enables us to have GDPR compliant processes? Or if we rely on sub-processes, as Mrs. Thiel talked about beforehand, do we have the tools to assess if those services are GDPR compliant? So, what's already in our toolbox? Is it sufficient to do the job? Let's find out in the discussion with our experts and, of course, with you. And to get the discussion going, we are delighted to have Mr. Kabir Barday here. Kabir Barday is the CEO of OneTrust. You see the logo here. A specialist, you might say the specialist for privacy management software. And he will give, I think, comprehensive overview about the state of tools for privacy compliance. Mr. Barday, the floor is yours.
Perfect, thank you. This is the clicker over here?
Yeah.
Okay. Excellent. Like you mentioned, my name is Kabir. I'm the founder and CEO of OneTrust. We're the largest provider of tools to implement the GDPR and the privacy program. I do have a computer science background, so I'm quite technical. Hold a Fellow of Information Privacy with the IAPP, and previously have won the Most Innovative Privacy Technology of the Year from the IAPP as well. So what I'll share with you today is a little bit of what I see in practice and some of the top 10 use cases for implementing tools from a GDPR and privacy perspective. So we'll really talk about 3 topics today in just about 10 or so minutes. The first is really what is so interesting and important about needing some software tools for GDPR. What are some example use cases to think about? What are some important use cases? And then where you can go find more information about all of the tools available in the industry and the market. And then we'll do a panel discussion as well on not just software tools, but all sorts of tools like codes of conduct and certifications as well. So the good news is that the job of a privacy professional is pretty easy. All you have to do is create a privacy policy and then make sure everybody's doing what the policy says. It's pretty simple. In fact, in practice, we all know that that very simple task is really complicated, what I call death by 1,000 cuts. Because if you really have to think about what is everybody doing, and is it following our policy? Well, you have use cases where you're a controller and a processor. Everybody has employees that you're a controller for. You have marketing information, you have processor information, you have marketing teams doing analytics, R&D teams using all sorts of information in your product for behavioral activity, IT teams doing employee monitoring, you have customers, vendors, government access to data, uses, secondary uses, tertiary uses, testing cases, retention periods. It's so complicated for even the smallest, simplest company to get their arms around what is happening in the organization. And not just that, but then starting to review things early before things actually happen. It's such a challenging problem in terms of how you operationalize that. And traditionally, I think everybody's aware what's happened in the market is this shift from a lot of the privacy professional's job being what I call paper compliance, which is maybe a spreadsheet or once a year audit that says you're doing what you say, but not having the actual controls to be what's called effective compliance, which is, are you actually doing what you say? And so a lot of the tools that have emerged in the market really help privacy become less of a distraction and less of a one-time activity, and more of really this continuous, what I call a reflex of the organization. How do you really put your fingers and toes in everything that the organization's doing, hold the business accountable, and not really have the burden fall all centrally on an individual privacy professional, and really scale that globally. And so there's some key things that typical privacy management software tools should be able to accomplish for you. So how do you operationalize the privacy and security compliance, identify the risks, maintain an evergreen visibility into your data flows, communicate transparently with choice, provide the individual rights, automate the regulatory record keeping. And if you do all of that right, it's not just about compliance. Compliance is just an interim step in what really the goal is. The goal is really to some extent, it's funny, if you implement a privacy program properly, you can actually use more data. And you can enable your business to say yes to using more data because you're confident that you're doing things responsibly, that you've minimized it, that you actually need it for the right purposes, that you're anonymizing it, that you're protecting it, and you can really foster innovation within the business. And that's really where the use of privacy technologies has grown significantly over really the last 1 or 2 years. This is a statistic from the IAPP. The IAPP maintains a listing of the privacy tech vendors, specifically that focus on implementing a privacy program. And you can see that in the last about 1.5 years, maybe, it's grown from about 50 vendors to about 160 vendors in privacy technology. So it's good news for everybody. More choice, more tools, more innovation, and really helping companies make sure they're doing responsible things with data. So that's a little bit of just the preface of why tooling for privacy programs has become so interesting. What I'll share with you next is just what we see in practice from the top 10 use cases that tooling can be really, really valuable in terms of helping automate and operationalize tooling. So the first thing I'll kind of mention in terms of how I think about and how our customers and the companies I work with think about privacy tooling is ultimately the goal is to protect personal information to some extent. And really I'll segment this into 2 parts of the market just to help contextualize it. The first is what I'll call security-related technologies. Security technologies really have existed for a very long time, and a lot of times our IT teams are already implementing this properly to some extent. And these are meant to do confidentiality, integrity, and availability. So you'll see things like data loss prevention, cloud access security brokers, and governance risk compliance, and things that are really valuable. But this is very different than the market for privacy tools. These are really focused on security. How do you prevent breaches and hackers? Privacy is a little bit different. There's an entire market called privacy management now that's emerged. And this is not about confidentiality, integrity, and availability. This is about how do you implement a privacy program and automate a lot of the record keeping, really focused on all the things that you've heard in the conference today. So very different tools, things like accountability and consent and data protection by design and record of processing and privacy incident management, really unique things that a privacy professional needs to be doing. So kind of the top 10 use cases that we see from within that privacy specific sphere. The first is what I'll call just a readiness and accountability tracker. These are tools that allow you to essentially track a central privacy framework, whatever the privacy principles and privacy framework that you live by an organization, whether it's a standardized framework like what the Cloud Security Alliance provides, or whether it's a GDPR specific framework. You can essentially analyze what you're doing as an organization and then choose what regulations you want to test that against, and then get very simple board reporting or project planning level outputs against many different laws, all from a single simple record keeping tool. The second really interesting use case that we see is record of processing. Now, record of processing always seems simple when you see the regulator's template, which is a spreadsheet. But in practice, we all know that's much more complicated, because to put a line to know what your processing activity is doing, well, there are many different IT systems that are involved in any single processing activity. And each of those IT systems might have different data transfers, different locations, different categories of data, different suppliers. And so to put a single line in a spreadsheet, it's actually almost this three-dimensional, many-to-many relationship between processes and applications, and then you end up kind of doing and filling out data. And this is, again, where privacy software tools can really excel in helping you capture and categorize that data and simplify it in an Article 30 report, for an example. And then you can take a lot of that data that's been documented from a record of processing perspective and help visualize it into what are typically called data maps. And these are more visual representations that can help you just really have insight into your data and data transfers and legal bases as well. So this is a very common use case that we see as well. Of course, the fourth one here is very common as well. DPIAs, privacy by design. A lot of what the previous speaker talked about, how do you analyze the impact, the likelihood, the recital 78 characteristics of risk across the organization. The fifth one that's very common is a vendor risk assessment and a contract management tool. The complexity here now, of course, when you think about Article 28 and how you analyze your processors and how you make sure your processors have the right technical and organizational security measures that are consistent with your commitments to your customers, this isn't just a questionnaire that you send to your vendors anymore. This is something that you not just send to your vendors, but then you have to figure out who are all your vendors' vendors and who are all the sub-processors. And this quickly becomes a very exponential problem. And how do you detect that and automate that and then not have it be a one-time activity? How do you continue to monitor and analyze it without needing an army of people? And these are both tooling solutions as well as framework solutions. Again, the Cloud Security Alliance, who's here, also has a really powerful framework called the CAIQ, C-A-I-Q. And they have a framework that standardizes this, makes it really easy for your suppliers, and you can import those things typically into a tool to automate the record keeping. Subject rights management is a really common use case as well. A lot of companies have an email address on their website that say, send me a request, and you can get a lot of junk mail. Then you have to validate it, you have to confirm it. The record keeping's a nightmare. You're sending spreadsheets of information over email. It's not encrypted, it's not secure. And then if that person leaves the organization, their emails leave and your record keeping leaves. And this is, again, where tools become really effective in solving subject rights requests. The seventh important use case we see is universal consent and preference management. How do you store records of consent when somebody's calling you or emailing you or filling out a form on your website? How are you properly storing and being able to demonstrate that consent? And then displaying essentially a self-service portal for your end users to sub-select what are the different things that they've opted in and opted out to. Because if somebody in your organization sends an email and you only give your end user the ability to opt out of everything, then that can have a really negative impact on the business. So you can give them different choices and sub-selections. Of course, one part of consent is cookie consent. I won't spend too much time on this. You all know the fun that we have with banners. Incident and breach response is really powerful as well. How do you handle the intake of an incident, really quickly analyze it against the different global regulations, understand what your notification obligations are, store a central register. And then finally, training and awareness management. This is something that can be effective, not just through training sessions that people have to show up to, once a year, but more incremental and more contextual. When somebody is doing or maybe launching a new activity, or maybe somebody is requesting funding for a new project, you can send them a very simple training activity, maybe a set of questions or a quiz with some videos in it, and actually score and benchmark the maturity of your organization over time in more contextual ways. So those are just the top 10 use cases we've seen in practice. But certainly I think we all know GDPR is not a solution that software can solve alone. The prereq to thinking about wanting to implement or invest in any of those tools is you almost have to try doing all this manually first. You have to learn what works for your organization. You really have to start with the right people and processes. And then once you figure all that out, it's about how do you make that efficient and scalable, and that's really where tooling helps from a software perspective. So if you are interested in learning more, there are a few resources I'd point you to. If you Google the Privacy Tech Vendor Report from the IAPP, this is a really interesting report about 150 vendors that you can look through and figure out what makes sense for you. Of course, OneTrust is one of those vendors. We have software tools that are widely used for all of the use cases we talked about today. We do have a completely free edition of our platform that over 10,000 companies use, actually. So you can just go to onetrust.com/free edition, or it's linked from our homepage. And you're welcome to start experimenting with different tools. And these are free forever of all of the editions of the platform. We also do a series of workshops around the world called Privacy Connect. These are completely free as well, where you can learn about best practices. And then there's also a very large privacy technology users conference we do in London in a week or two called Privacy Tech. So just to wrap up, we're also very famous for our GDPR books. We're the world's largest publisher of the GDPR text. And so we did bring a few copies in both German and English. So if you do want a copy of just the text of the GDPR, we have a team, our local German team here, that can, of course, you can grab one at our stand later today. So hopefully that's helpful in giving you some insight into some of the tools and can help you do what your policy says in an efficient way. Thank you.
Thank you very much, Kabir, for this great introduction to our subject. But let's dive a little bit deeper into the aspect of GDPR compliance tools. Dive deeper together with the experts on our panel. Kabir, you know already. We are going to discuss with Mr. Jörn Wittmann. Jörn Wittmann is Managing Director of SRIW. I'm not going to try to spell it out completely, and also of Scope Europe. And Jörn is one of the most renowned experts in the area of co-regulation, especially codes of conduct. And also together with Dr. Fabian Niemann. Fabian Niemann is the head of Bird&Bird's data protection practice. I think Bird&Bird doesn't need an introduction. And he advises companies on GDPR and compliance matters ranging from DAX companies to SMEs. I would like to start with you, Dr. Niemann. I keep hearing that the GDPR in some provisions is rather vague, and I tend to believe this. So how do you and your clients deal with the uncertainties, with the vagueness, and maybe as important, how in your experience are the supervisory authorities dealing with those vagueness and uncertainties?
Thanks. It is the GDPR. I don't give it a triple A. I usually say it's a triple F. It is fantastic, fascinating, and frustrating. It is fantastic for lawyers. Many people say it has been written by lawyers, probably not by lawyers' husbands and wives. They will be interested to have some statistics from Google about divorces in the last years amongst privacy lawyers. But so it's tremendous amount of work. Obviously, it is fascinating because it's all unclear. It is new, so you can be creative. But it's also frustrating because of the vagueness you're mentioning, and business decisions are depending on, can I do this, can I do that? And then you look into the GDPR, and then you see, well, reasonable, appropriate, balancing. We heard a lot about privacy by design, but do we know what that actually means, what you have to do? So this is all very unconcrete, not very helpful when there's so much administrative burden. What we learned about where we can use tools, records of processing, DPIAs, data processing agreements, data breach notifications, and my personal favorite, which is the newly invented processor records in Article 32. So for those who don't know it, processors are supposed to have a record of all controllers. So imagine a Google and Amazon and Microsoft is obliged to have a record of all people who are on their platforms. You would expect such a regulation, which is very creative in many laws, but certainly not in a privacy law. But well, there it is. So how to deal with all that? That's very unpractical. And I think the GDPR, one of the good things of the GDPR is the reference in many stages to certificates and to code of conducts in the basic provisions in Article 24 and Article 28, but also when it comes to security, international standards, there's always this reference. And this can be in combination with tools which are then certified, which are general code of conduct, can help a lot. And that's actually what clients are also asking for. How do others do that? It's also vague. So, I mean, we can read the law, but maybe you can tell us how the peers are doing it, because then you feel somehow more protected. And because indeed you're asking what are data protection authorities doing here, I mean, they're human beings like we. They have the same text, same vagueness, and we all know that the guidances come rather late, and they are not all here, and frankly, and that's no complaint, but if you read the guidance, you say, okay, I'm not necessarily more intelligent than I have been before on the issue. You get usually some more concrete answers if you're in one-to-one communication, but it's so complex. So I think we urgently need standards and tools which are certified, which are accepted, where companies can rely on. If I use this tool for information notices, if I use that tool for data subject request, if I use this procedure for data breach incident, then I'm compliant. And that's what we're absolutely missing, and what the vague GDPR is crying for.
Mr. Wittmann, following up on what Dr. Niemann just said, do you think that the regulator could have been more precise when formulating the provisions of the GDPR, or is this vagueness by design, or do you think that the GDPR not only offers problem but also a solution to this question?
I think the regulator might have been more detailed when drafting the provisions of the GDPR, but I'm actually happy that he wasn't, because I think the regulator didn't have much of a choice. In the innovation-driven area, like the data economy, like in the digital age, innovation speed is so fast that I think the more you go into detail in a regulation, the higher the risk is that at the end of the day you will end up with a regulation that is not applicable in practice anymore. Maybe in the moment it is applicable, that regulation. So yes, I think it shows the right solution by more focusing on defining goals and leaving room for interpretation and practice. But of course, I understand that creates frustration, but also business for the consultants. But there must be a solution for that. And I think also here, what I would call modern regulation, the regulator made actually a good choice by giving the people using that regulation tools on hand to concretize these vague provisions. We heard it already, codes of conduct, certifications. Also the European Data Protection Board has the authority to provide guidelines. I think these are tools that should be used and that can be very well be used in practice. And I would like to say a little bit more about codes of conduct, how that looks like. I mean, we heard now a little bit already. Drafting such a code of conduct, how the process looks like. So I think the regulation says you start with the sector, with the industry, saying, okay, we have now a specific problem, concretizing the GDPR in practice in a specific scenario. So you bring together a group of companies, maybe in a trade association, maybe in a different way, and say, okay, now let's find a solution to that, let's concretize that, write it down in the code of conduct, and then let's talk with the supervisory authorities and see if they like what we wrote down. Usually that's not the case. So then you start a bit of a negotiation process, and at the end of the day you hopefully end up with a result with which you can prove your compliance, with which you can say, okay, now I know I'm compliant with the law. And I think what we just heard about technical solutions to implement in my opinion, the first step always has to be to first concretize the law and then use technical solutions. I think that's what you meant, Kabir, with figuring out what you actually have to do. Use technical solutions to implement that what you just figured out that could be the right way in practice.
Okay, Mr. Barday, you listed the top 10 of the questions to be answered. Your clients, and I guess you have more than 2,000 companies that you're serving around the world, also have to deal with this vagueness that we are talking about. So if we would boil down the top 10, are there one or two questions where you would say, this is really the most common pain point for our customers? So what is really what are really the most pressing issues for our customers?
Yeah, so we work with clients a little bit further in the implementation of GDPR, where the interpretation of GDPR isn't necessarily the biggest challenge. They've made a decision on the interpretation, and they might change it over time, but that decision has roughly been made. So the really specific challenge that we see in the market is quite simple. It's how do you keep your record of processing up to date? It's that simple. And so many companies did a GDPR program to get ready for GDPR, went around and asked questions to everyone in the business, generated that record of processing, and it is out of date the very next day. And keeping that up to date is a surprisingly very complex task because you have existing processes that are changing and you have new processes that are coming in. And so what we've really seen a really solution around is, if you really think about your privacy assessments, your privacy by design, as an input into your record of processing and a way to keep that up to date, as well as your incidents as a way to keep that up to date, and for your vendor management and your vendor reviews to keep that up to date, surely you're not going to get 100% and capture 100% of everything still. So there has to be some sort of annual reassessment and all of those things. So this is a challenge that obviously tooling helps with. But again, like we talked about, you have to have the right people in process to actually implement that in a thorough way. And then what will happen is maybe the interpretation of GDPR will change halfway through, and how do you fill those gaps? And this is something that I don't know that there is a perfect solution for. A lot of companies come to us and say, do you have a magic voodoo scanning technology that'll generate this for me? And this is impossible, because how do you scan for purpose of processing? How do you scan for data minimization? How do you scan for legitimate interest? And how do you scan for the balancing test? And there has to be, what I always say, smart people working on hard problems. And really the goal of standardization and tooling and all these things is to eliminate all the administrative overhead. And there's still a lot of work to be done and a lot of good power, but you want your smart people working on hard problems, not repeating the same questions over and over again. And that's really probably the most specific thing we see.
Yeah, it's interesting. It also comes back to the metaphor I used at the beginning with car manufacturing. I mean, putting a car on the road is one thing, but keeping this car running, improving it throughout its life cycle is definitely a different challenge. So there are still those parallels, interestingly. Dr. Niemann, you are advising clients all around the world in different legal systems. From your experience, this GDPR vagueness, if you compare it to American privacy law, Asian privacy law, are there substantial differences in the level of certainty or concretization? Are other legal systems easier to deal with than the GDPR?
Well, the GDPR is probably the only big data-related product which is a big global success coming out of Europe and not the US. So many laws are actually similar to the GDPR, but fortunately for us lawyers, unfortunately for companies, they are not all the same. There are, in terms of vagueness, which, as you had said, has a certain sense because you have to keep up with technology. You see that in more or less all laws, those which are based on GDPR and those which are a little bit different. Where you have, frankly, more concreteness, particularly in the US, if it's regarding IT security, what you're actually required to do. They tell you in HIPAA and some acts very precisely what you have to do, what is missing here. And what is also, it's less the vagueness, but the administrative burden of the GDPR on normal businesses is so tremendous. And if you look into the newly issued California Data Protection Act, the CDPA, which took the GDPR as master, but it actually is the kind of the material essence of the GDPR without all this administrative horror. Okay, they only had 6 days and not 6 years to issue it. So yes, the laws are different, and what we seen quite often is the GDPR as role model for many laws, which are slightly different, but usually being more tough. So many companies are actually going for the GDPR as global standard now. Maybe they got bored by the European GDPR project, so extending it. No, seriously, but that's one solution we see more and more discussing GDPR as global standard, but it doesn't solve the vagueness. It's just there. There we need the tools again.
Yeah, Mr. Wittmann, we heard the public or the customer is crying for tools, for standards. Software to support those processes is already on the market, but the other important aspect, certification, code of conduct, Article 40, Article 42, how far are we at this moment in this area? What do we have in our toolbox, so to speak, to answer the question from the beginning?
So you want to know how it is already adapted in practice, these tools that are available?
And what's the perspective? So if we don't have the screwdriver now, when will it be delivered?
Okay, so I would say right now we have a moment of momentum in codes of conduct and certifications. I think there are a lot of projects going on right now. I mean, we are involved in credit debt code of conduct, in a cloud code of conduct, in mHealth code of conduct, in certification related to cloud. So there are a lot of projects going on. I'm pretty sure there are a lot more going on. And I heard even of one that was already approved by the German DPA here in Berlin. So there is a lot of momentum right now, because I think there's just a need for concretization, as Mr. Niemann already said. The people are crying for, just tell me what to do and then I will do it. How the perspective is, I think that depends on what the DPAs are willing to do of that tool. If they ask always for the maximum, or let me rephrase it, maybe to say, if the companies always try to deliver the minimum and the DPAs always try to achieve the maximum for concretization of the GDPR, I don't think we will see a lot of approvals out there for codes of conduct or certification. And that would lead to the same situation maybe as it was under the directive, where the tool was also mentioned, the code of conduct, and was never really used, that it will just not be adopted in practice. So I think, from my perspective, to give it a chance for the future would mean that both sides have to move a little bit to each other, find a solution to really implement GDPR in practice, and then not forget, with tools like certification and codes of conduct, there comes also a stronger law enforcement with it. So that means you will have private bodies, whether a certificator or a private monitoring body, coming as another pillar for law enforcement on the field, which is also hiring the rights of the data subjects. So in my opinion, that's how I see it, and I think we just have to go out, draft few codes of conduct, have good talks with the DPAs and see how it comes out. But at the end of the day, a GDPR at least says we only need a majority vote within the European Data Protection Board, which is a huge difference to how it was before in Germany, for example, where you always needed full consensus for an approval within the Düsseldorfer Kreis, the representation of the DPAs here in Germany.
If I may step for just 1 minute out of bounds of the moderator, especially for the guests from abroad, I want to mention that once upon a time, here in Germany, we had such a tool, which was called TCDP, Trusted Cloud Data Protection for the cloud environment, which was developed together with the authorities, which was, I think, a very good certificate. Only one small thing, it was based on the old German Bundesdatenschutzgesetz, so on the old German privacy law. So, it can't be used that way anymore, so the German Ministry of Economic Affairs and Energy has set up a project which is called Auditor to implement a European GDPR-conform certification, which is right now also in discussion with the authorities, and also, as you know, Article 42 has to be accepted by an accreditation body with the German accreditation body, the DAX. So I think we had now 2 rounds on the panel, but we would, of course, like to field your questions. So what are your questions on GDPR compliance tools? Grill our experts. They're here with their knowledge to serve you. So, questions? So that means, yeah.
You have to hold it really close. Okay. I have a question for you. You said that like no compliance tool work without like input from the company, and I totally agree with you. I just wanted to ask, from your experience, how much time and how much effort, does a company, a big company, multinational company maybe, needs to implement, like it needs to put into this tool to make it work? Because it looks great, and I know the tool, but our clients, like they have difficulties to fill in the information into this processing records and to keep them updated. So what is your experience?
Yeah, so I'll break it up into 2 parts. The first is what's the time it takes to get some sort of tooling up and running and implemented, and then I would separate that from how much time does it take in business as usual mode and in an operational mode. And in general, it varies pretty dramatically based on the use case. So a tool like subject rights management is actually very easy to implement. I mean, you're talking about a few hours of time. These are very simple tools, ranging from a cookie tool, which might take a few weeks, to data mapping and PIAs, which are also quite simple to implement. Now, the more challenging part is in an operational mode. Most of the tools, obviously subject rights, depending on how much you want to automate in the fulfillment, it's going to vary dramatically. So if you choose to automate a lot of the fulfillment of the request, meaning going and finding the data automatically, that can be very fast. But if you have a manual process to go find the data, then these can individually be very expensive. So there's a spectrum there, and it's always a it depends answer. I would say the one consistent answer that there's just no easy way out is the record of processing. This is one tool that no matter how much software you invest in, it's difficult. And it requires involvement from the business. That's how you scale it, is through the concept of privacy champions. And the way it scales is through holding the business accountable for spending small amounts of time populating things and not necessarily centralizing it. So that's probably always a tough one to, like you mentioned, entering data. That's usually a private record of processing challenge. But everything else, the goal is to implement. And even in that record of processing challenge, if people have to spend work on it no matter what. And that's where I always go back to. If people are spending time on it, you want to make sure that work is reusable, it can be kept up to date, and you don't have to do these huge interview activities over and over again. They can just be incremental. And the other parts of how tools start to become more efficient is if you do master that record of processing, you can then start to think that everything else just got easier, because fulfilling a subject right is dependent on knowing what data you have and the legal basis. So that becomes much more efficient. Knowing the impact of an incident really depends on what's the liability in the contract, what's the data that was sent, what are the data flows that are impacted, and so you have an easier way of analyzing risk. So if you really spend the right amount of time nailing your data map and record of processing, everything else can be easier, but there certainly is an aspect of time.
It's like the biggest pain.
It's a pain no matter what, yeah. There's no shortcut to it. I mean, you're absolutely right, yeah.
Further questions? No controversial issues here, I see. Okay, then we have time for one more round on the panel. Mr. Barday, of course, OneTrust covers with its tool the whole range of requirements, but looking into your roadmap, what do you regard as the biggest challenge ahead to further develop GDPR compliance tools, software?
Yeah, for us it's increasingly going from when you're in a GDPR preparation mode, a lot of it is around record keeping and demonstrating compliance. And how do you shift the record keeping to really having the right technical controls deeper in an organization? So consent is a good example of that, but there's a lot more things that are needed around anonymization tools and pseudonymization tools and more automated kind of discovery type tools. And then you also have to think, a lot of the processes that you implement from a data protection and privacy perspective are very generic, right? You're doing a privacy by design checklist, but it's generic whether you send it to HR or marketing or a developer. And where the market is going to have to evolve based off of codes of conduct and things specific to individual use cases is how do I send a privacy by design checklist to a marketer that has very specific marketing terminology and things like this. When I send a checklist to an app developer, I should be asking about log files and are the username or passwords logged? When you turn the logging up to debug mode, what's being done? Is it encrypted? Is it not encrypted? What are you storing in NS user defaults in the app? Like very technical questions, because if you just ask an app developer, are you storing data, yes or no? It's out of context, and I think that's how the market is going to continue to evolve.
Dr. Niemann, a Good Ferry comes along and says you are allowed to change one thing in the GDPR to make it clearer, but only one thing. What's your wish towards the Good Ferry?
To make it clearer, or can I go beyond that?
You can go wherever you want, but it's only once.
One thing. I think the worst thing about the GDPR and previous data protection law is the idea that it applies to everything. There's no kind of de minimis. Every Axel of Siemens said is every contact data, there's so many things, every pizza delivery service, everybody is covered by it. So if you look into other laws like copyright, you have a certain threshold, need to be creative. My wish would be that personal data would have to have a certain kind of sensitivity to trigger all this vagueness, administrative burden, and mess. I know it's not realistic, but I would have wished that that this would have happened, or maybe it happened sometime in the future.
Okay, thank you. Mr. Wittmann, when I look at the GDPR, it looks like it's been written by someone who grew up in the host on-premise world or in the application service provision world. So a clear world where you had one data center, one processor, and more or less linear processes. In the cloud environment, things are radically different. I mean, we can start about sub-processing, which is not really a linear case, but interwoven. We have instances where Docker containers will exist for a few seconds, but then disappear. So what's your take? Is the GDPR already outdated, or can it be adapted to an, let's say, cloud/edge environment?
I actually think it can be, but it's very clear that it was written against a different background. An old thinking, or older thinking when it was drafted, that for example, there was big data already in mind. That's why we have some certain exceptions in the law. But it's pretty clear that, for example, technologies like blockchain were not yet in discussion. So I think when we are now discussing the interpretation and the concretization of the law, we have to be very careful to not be too detailed and too strict in certain areas that we block future technologies by that, because then, for example, if you have a guideline from the DPAs, from the European Data Protection Board, trying to address a certain solution, being too broad when addressing that solution can happen that blockchain, for example, will not work out. So that's why you have to always keep in mind that new technology is coming up, and you have to make sure that it's still applicable, and also the old guidelines are working with that.
Okay, time's up for the discussion. I'm afraid we couldn't get into every tool which is part of the toolbox, but I hope you regard this time here as well spent to get a first overview of the state of tools for GDPR compliance. I thank you for your attention and wish you a further very successful privacy conference here in Berlin. Thank you.